The next case here today is Dave versus Jarrell. Each will have 15 minutes to present the argument. Counsel, how long would you like to reserve?
Your Honor, with the court's permission, I'd like to reserve 5 minutes.
The court will note that. Arguments are being recorded.
Yes,
When you present your argument, please introduce yourself. Keep your voice up, stay behind the podium.
Yes, sir.
So that we can record you.
Yes, sir.
Do not use the name of any child, minor, or victim during your argument, so please refer to them by initial to term like the child or victim if you would.
Yes, sir.
We read your brief and ready to proceed whenever you are.
Yes, Your Honor. Please, the court attorney, App.No, on behalf of Mr. Jarrell, the appellant, I would like to reserve 5 minutes. Your Honor, the issue I have really goes to the first assignment error and this dangerous slope that this case creates. The testimony of the Dr. Savitsky, and I know I'm probably butchering her name, and I apologize for the record, with regards to a completely speculative line of testimony with regards to date rape, and I'm using the term date rape generically, narcotics being administered, when that specific expert has no basis of knowledge for that information. This court would not permit this in any kind of other case, and it should not allow it to permit in this case. In this case, what was being testified to, and there was no indication that there was a degree of medical probability, was the idea that this is what date rape drugs can do. And we all agree, and I don't think anybody in this courtroom is going to disagree with the idea that date rape drugs obviously are something that can impact a rape case. The question is what is the relevance to the facts in this specific case?
I was trying to think of that. I was thinking of DUI cases, but I was thinking more of the line, and we're going to get more and more of these now with the legalization of marijuana.
Right.
And we've had many cases with supposedly prescription drugs and the effects that they've had. So why would it be improper, or are you saying it would be improper, if it were a case involving impaired driving, that an expert would take the stand and say what the effects of a particular drug were?
I wouldn't necessarily, I guess I would not necessarily have an issue with that if you could correlate and link that to actual testimony, okay? So for example, if you had, and I'm going to use the DUI case because it's just an easier one for me to use and analyze. If you were to have a DUI case and the expert comes in and says, we expect X, Y, Z in a person who uses marijuana and drives a vehicle. And I've never done it, so I have no idea what the complete effects are. Let's just say bloodshot eyes, slurred speech, whatever we're going to use for alcohol as well. And you can actually show a correlation to the defendant's conduct or defendant's medical records, whatever it is. That might be a case where you could say that at least there is a causal link there. But in this case, we don't have the underlying testimony to support. Even the DUI case, I would say I think you still need a little bit more because of the prejudicial nature of it. I mean, when somebody's hearing from an expert witness, we can tell the jury until we're blue in the face that you are to weigh this person's credibility with the credibility that you weigh everybody else. But with any kind of expert witness, you put anybody in front of a jury and you put the initials doctor in front of them, or MD, PhD, whatever after them, the jury is automatically going to give them an inherently higher amount of weight.
But if the only testimony is, for instance, that the test results came back negative, so what does that mean? The state shouldn't be allowed to explain that through some expert testimony that somebody can come back with a negative result and still have been under the influence of some type of drugs.
I think you still have to show the link between it, and I think you have to establish that link through the testimony of, let's say, the victim in this case. You have to show the link through other behavior in this case. But if I remember correctly, in this case, the narcotics, or I'm sorry, that the videotape did not support that there was a drug administered, that there was nothing that indicates.
I'm sorry.
Yeah, go ahead, Judge.
Except that it may not have shown actual pouring of drug into the drink, but she was falling over. She couldn't even walk. Right. I mean, all those things that usually, I mean, seen a lot of intoxication cases and so forth, and impairment cases in regard to that. But this seems like it was beyond what you usually would see just with somebody drinking alcohol.
But my issue goes to the testimony itself.
Well, counsel, on that point,
Yeah.
didn't the victim specifically testify that she didn't consume a large enough amount of alcohol to cause her to have the memory lapses that she experienced? And didn't sort of the videotape all of that together, couldn't that have created some impression for the jury?
It could have created that impression.
And that link.
But I think you still have to show something more than just, you know, I mean, I assume everybody in this room has drunk before. I think you still have to show that there is some link before you start introducing the inherently prejudicial testimony of an expert witness.
Well, then how do you discount the victim's, or the, testimony that she did not drink enough to cause these?
I think that would be an issue for the jury in a way as to whether or not, and that's where I return to. I mean, there can be several different factors as to why a person has an individual reaction to alcohol. I mean, food consumption, what the food was, medications the person was on, things like that. But to jump to that there's a date rape drug administered when the test results don't show it, there's no indication elsewhere other than that she had an adverse effect of the alcohol. I believe she could testify that she had an adverse effect of the alcohol. My concern is when you start putting an expert witness on the stand to say date rape drug, date rape drug, date rape drug, that you all of a sudden create this inference in the jury's head that there was a date rape drug administered, and that's where I think you go to the prejudicial level. That's where I think you cross into it is inherently prejudicial to say, and that's why we have the gatekeeping
Counsel,
rules.
but the jury heard that the test administered did not show it in her system, correct?
Right.
And the expert was subject to cross-examination, correct?
Agreed.
Okay.
Yeah, I'm saying it shouldn't come in the first place. That's what I'm
I
saying.
have a question.
Yeah.
And, the way it was charged, you didn't have to prove that it was a date rape drug was used.
No, it was just under the impairment.
So how is this not harmless error, even if it is error?
Because I would argue that it's unduly prejudicial, and that's why we have the gatekeeping rules to say, look, this kind of testimony should be limited to where there is a causal connection, and there is no causal connection to. It is completely speculative that a date rape drug was administered.
Well, I guess what I'm saying is and I haven't reviewed the videos yet,
Right.
but I would like to look at the videos.
Yeah.
If you have a person falling down face first on concrete, how in the world can they consent to having sex?
Well, that would rise to a question for the jury to determine whether or not that was.
But I'm saying
that
there
wasn't
seems
that
to be
level.
overwhelming evidence, that's what I'm getting at.
As far as intoxication, I would say that there is evidence to support it. But once you start adding in the additional element of the possibility of a date rape drug, that's what I'm saying is I think that it crosses over into, that it's not harmless error at that point. We're crossing into a level where you have the victim's testimony combined with the other testimony in the case, including evidence that supports the appellant, and then you add on this extra weight. It would be like throwing a 3-pound barbell onto the scales of justice. You are going to slam it down. That's what I'm saying. It crosses that line into that actually this would be error. And I believe that the only reason that the state would have introduced this testimony in the first place is to try to prop up a case that they saw that there was a weakness in her testimony and her story, also timelines, things like that. And so I'm not saying that there was not evidence of intoxication. What I'm saying is that when you add in this expert witness that is based on the facts of this case and the testimony of this case, and cannot say that her opinions were not provided to a reasonable degree of the probability, you're introducing evidence that should not be in the case at that point, unless there is something to actually substantiate and support the idea that a date rape drug was administered. So, and that's what I'm returning to. That's why I was focusing on the first assignment of error, is the concern, not just in this case, but in cases going forward, is are we introducing expert witnesses where expert witnesses should not be introduced? And that is a gatekeeping role for the courts to commit, but we do have the rules to support it. We should not be introducing expert testimony just for the sake of trying to bolster up a case. It should be being introduced because there's relevance, there's causal connection, and because otherwise you are confusing the jurors. And without having spoken to the jurors afterwards, that has not relevant, but you don't know what weight they actually would have placed into this expert testimony, which is why expert testimony has to be restricted to cases in which it's actually applicable.
I don't want to interrupt you, but I know you're getting to your rebuttal time now.
I was actually about to say, unless there are any additional questions, I was going to.
Thank you.
Thank you.
May it please the court, Heaven D. Martino on behalf of the state of Ohio, the appellee, we are asking that this court affirm Mr. Jarrell's convictions with regard to the first assignment of error and the testimony of Dr. Savitsky, who was an expert. The state would first point out that Dr. Savitsky specifically testified that she was not rendering an opinion as to whether or not the victim in this case had consumed any type of a dangerous drug.
Well, why was it relevant? How was her testimony relevant to these particular facts?
To these particular facts, Dr. Savitsky was testifying with regard to what happens in an assault, specifically someone who's been sexually assaulted. And her testimony was dovetailing on Nurse Bailey's testimony, who was a sexual assault nurse examiner who testified about red flags and the protocol that's used with regard to a SANE examination. And why, when she saw the victim, she believed that the victim, one, was a victim of sexual assault, and two, that it could have been some type of DFSA, drug-facilitated sexual assault, which included protocols for SANE nurses. And then
Drug-induced could be just alcohol.
Correct, and Dr. Savitsky specifically testified that in drug-facilitated sexual assaults, the most common drug that's used, or intoxicant, is alcohol. So it was to show the impairment and the impairments that can happen because of alcohol and how the body metabolizes different substances from alcohol to GHB, and why in one person a certain amount of alcohol might have a particular effect, but it might not have the same effect on another person based on just metabolism. And how if you do have a negative test result, specifically for something like GHB, that does not necessarily mean that you did not consume GHB. So her testimony was designed to help the jurors understand information that's beyond a layperson's understanding, which is the impairment that can happen and how that can present itself with regard to a sexual assault.
Okay, well, how does, if we say that this was permissible to bring in this case, how is it not permissible then to bring it in every case where there's alleged rape due to alcohol impairment, for instance?
So I would say it would be a case-by-case basis to look at the facts. In this particular case, you have someone who has memory lapse from the time she gets into the vehicle and consumes the water that she said had a cinnamon-like taste until she basically is at the police station with some memories in between. So if you have this level of memory loss that cannot be explained by the victim, she testified that she's consumed this amount of alcohol before and hasn't had this effect. So I think if you have that type of a fact pattern, then it would be applicable. In other fact patterns, it might not be, if you don't have like that memory loss, for example.
Well, there's a lot of cases where there's memory loss.
Right, and if there is,
that's one of the things that the jury looks at in determining whether or not the defendant would have known whether or not the person was impaired to that extent.
and ultimately that was what the state had to prove was she incapacitated, and did the defendant know, or should the defendant have known, right? So in addition to the videotape, and I would argue that even if it was error, it was certainly harmless error. I don't believe it was error in this case, but once you look at the videotapes of this particular case, this lay person could look at it and determine that this person was intoxicated. She's, at the first bar with her head on the table. She's falling down. She has to be picked up off the ground. She's stumbling. All of the things that are kind of textbook for what incapacitation is. And then in addition to that, you have Detective Kalecki, who testifies as they play the video again to point out how those things are red flags to show the incapacitation. So even if there was an error in allowing the expert to testify as to metabolism and drug-facilitated sexual assaults and SANE nurse protocols, it would be harmless error. But this case would be different from a DUI because there is specifically that issue of what happened with regard to a sexual assault and what should a SANE nurse do and why does a SANE nurse do the things that they do? Where did that protocol come from? And what are the red flags and how did the red flags get established? And Dr. Savitsky was able to testify to that based on her training and her job, how red flags come into play with sexual assault. So it is different than a DUI, but I do understand, the court's concern with regard to, are we gonna be introducing some expert that's gonna testify about potentially GHB or other drugs every time we have a DUI that's based on whether it's marijuana or something else.
He raises a good point in regard to, these cases are always hard to try. This one seems like there's a lot more evidence in regard to the videotapes and everything, hold on. But the moment you mention to a jury the possibility of a drug-induced rape, that somebody's been roofied, that is kind of prejudicial if there's no evidence of it.
I would say, one, there is evidence of that, but two, when you read this transcript and you look at the videos and you hear Dr. Savitsky say she is specifically not saying to a reasonable degree of medical certainty that this victim ingested a drug-facilitated, substance. Honestly, to me, it's all about alcohol and it's all about the impairment and just the impairment. The testimony with regard to GHB is so minimal, I don't believe that it is inherently prejudicial. I hear what opposing counsel is saying, but it is mentioned in the context of all of the things that can cause impairment that they look for with the drug-facilitated sexual assault. The doctor is specifically talking about how important alcohol is, but just talking about metabolism and why you can get a negative test result, there was no push towards, see, it could be GHB. When I read it, I had to go back a couple times to really even see where the prejudice could be based on this testimony, because it was very clear that no one was saying this is probably a drug-facilitated assault. What the point was is that this woman was clearly impaired to the point that she was incapacitated, didn't know where she was, how she got there. That was the issue. And then there was a sexual assault.
What was argued in closing statement by closing argument by the state?
To the best that I can recall, the closing argument was just about the impairment and that there was testimony with regard to drug-facilitated assault. I do not believe that the prosecutor tried to say that this was induced by the roofie, just to talk about metabolism. And the point of the elements, which is to show that there was incapacitation, which Mr. Jarrell and Ms. Hutchinson should have been able to see throughout the course of the evening. If there are no further questions, I would rest on my brief and ask this court to affirm. Thank you.
See no further questions, thank you. You have your full 5 minutes for rebuttal.
Thank you. Irony of this oral argument is we're doing this during the middle of the Puff Daddies, the Sean Diddy Combs case, which I believe was the second or third story yesterday on the news. That when people do hear about these roofie, to use Judge Carr's word, that it does raise an automatic level with people in the community. And I'm not saying that that's not a good response for the community to have, but for the jury to have, it becomes dangerous because all of a sudden, when the prosecutor, when the state's admitting that there wasn't support for this idea of a drug-induced, but we're going to introduce testimony about it, they're going to what I'm saying is that it's not relevant to this case.
I'm not sure the state is conceding that there was no evidence of it, because the whole point was she testified that it was beyond her usual intoxication, for drinking what little she did. And she was literally falling down all over the place. So, and then it's my understanding that the physician testified that those can be indicia of something more going on than alcohol, because those are the things they look at.
They could be, but when there's not medical evidence to actually support it is what I'm trying to say, okay? When the doctor gets up and says, I can't say this, but then throws out a whole speculative line of testimony, that's my issue, is that we're dealing with one of those triggering words or triggering phrases, when you start to accuse somebody and put in testimony that says drug fueled, this is the effect of drugs, things like that, when there actually is no testimony that supports a conclusion that there was drugs being used. And it could have been somebody had a bad night with alcohol. It could have been that she was drinking something that she wasn't used to drinking. And that would have been acceptable testimony. I'm not arguing with even the Dove Sane nurse's testimony as far as relevance. My concern is with Dr. Savitsky, who agrees that she never reviewed the charts, never interviewed the witness, and then says there was no evidence of impairing drugs being used that night. That's what my issue is the relevance and then the prejudicial nature of that testimony. That's where I have a serious concern with it. And does that prejudicial nature then sway the jury and essentially put blinders on them for the rest of the testimony? And so that's why I'm asking the first assignment of error that this court reverse and remand the case back to the common police court for further proceedings. Unless the court has any other questions. Thank you very much, Your Honors.
Thank you. The court will take the matter into advisement and issue decision in due course. When that decision is reached, it will be mailed to you by the clerk of courts and also available on the High Supreme Court website.
Thank you,
With that, I'd like to thank both of you for your presentation this morning on behalf of the court.
Thank you very much, Your Honors.